BNP Paribas Suisse SA versus Ashok Kumar Goel and others, a recent ruling on the execution of foreign decrees in India. Hello everyone and welcome back to Legal Bites by INDIALAW LLP, your go-to podcast for quick, precise and insightful updates from the Indian judiciary. I am Brian Narona. Today, we are discussing a significant judgment from the Honorable Delhi High Court in the case of BNP Paribas Suisse SA versus Ashok Kumar Goel and others, which was pronounced on 19 September 2025 by a learned single judge of the aforementioned High Court. This decision addresses an important question in the field of enforcement of foreign decrees in India. Can a decree passed by a foreign court in a reciprocating territory be executed simultaneously in India and the foreign country? Let's unpack this case and understand its implications. The case arose when BNP Paribas Suisse SA, a Swiss bank, sought to execute in India a decree passed by the Sharjah Court of Appeal, United Arab Emirates, dated the 10th of October 2023. Under that decree, members of the Goel family and associated Gulf Petrochem entities were directed to pay the bank a staggering $118 million, which translates to approximately 991 crore rupees, along with interest and costs. Since the UAE is a reciprocating territory under Section 44A of the Code of Civil Procedure, the bank filed an execution petition before the Honorable Delhi High Court against 4 individual judgment debtors, all Indian residents with assets within jurisdiction of the Honorable High Court, while also pursuing execution in the UAE. The Goel family objected to this simultaneous action, raising questions on the decree's finality and the maintainability of dual enforcement. It's also important to highlight here that this decision has been challenged before the learned division bench of the Honorable Delhi High Court, which is pending adjudication as of the date of today's podcast. The court framed 2 central issues for determination. First, whether the UAE decree dated 10th October 2023 was final, valid and executable in India under Section 44A of the CPC, and whether simultaneous execution of a foreign decree in both the cause country, that is where the decree was passed, in this case the UAE, and the foreign country, that is in this case India, is legally permissible. The judgment debtors argued that the foreign decree had lost finality due to subsequent corrections and pending proceedings before the appellate courts in the UAE. They relied heavily on the decision of the Honorable Supreme Court of India in Bank of Baroda versus Kotak Mahindra Bank Limited, reported as 2020, Volume 17, Supreme Court Cases, page number 798, asserting that execution in India is only permissible after proceedings in the foreign jurisdiction are fully concluded. They also contended that the pendency of UAE execution proceedings barred India from entertaining a parallel petition to prevent what they termed dual enforcement. On the other hand, BNP Paribas, the bank, argued that the decree remained valid, binding and unsatisfied, and that multiple precedents clearly held that simultaneous execution where the judgment debtor possessed assets in more than one jurisdiction was permissible under Indian law. The bank stressed that the decision of the Supreme Court in Bank of Baroda dealt only with limitation and not with maintainability or permissibility of concurrent enforcement. The learned single judge undertook a detailed examination of Section 44A of the CPC, which governs the execution of decrees from reciprocating territories, as well as Sections 13 and 14 of the CPC, which define the conditions under which a foreign judgment is presumed to be conclusive and binding. The court observed that the Sharjah Court of Appeal's decree had been reaffirmed multiple times, most recently in June 2025, and had accordingly attained finality under UAE law. The court also noted that non-satisfaction certificates dated 15th October 2024 and 20th March 2025 proved that no part of the foreign decree had been satisfied. On this basis, it was held that the decree satisfied all requirements under sections 13 and 44A of the CPC, being that it was pronounced by a court of competent jurisdiction, it was on the merits of the matter, it was in accordance with due process, that is, the principles of natural justice were not violated, and it was not contrary to Indian law. Now, coming to the core issue, whether a decree can be executed in India while proceedings are also pending in the foreign country. The court answered yes. The learned single judge emphasized that Section 44A, subclause 1, creates a legal fiction treating a decree of a foreign superior court in a reciprocating territory as if it were a decree of an Indian district court. Citing the decision of the Honorable Madras High Court in Sheikh Ali versus Sheikh Mohammed, as well as of the Delhi High Court itself in Oakwell Engineering versus Enernorth Industries, the court explained that this fiction allows all consequences of a domestic decree to follow, including simultaneous execution in multiple jurisdictions. Importantly, it was noted that there is no statutory bar in Section 44A preventing such concurrent enforcement. The court further clarified that the decision of the Supreme Court in Bank of Baroda did not prohibit simultaneous execution. It merely addressed the starting point of limitation when execution is first attempted abroad. Further, it cited cases such as Premlata Agarwal, Cholamandalam Investment, and M.V. Alkomar to rely upon and reinforce the principle that where assets lie in different jurisdictions, simultaneous execution ensures effective and timely recovery. The court also took note of the dilatory conduct of the judgment debtor group and family members, including non-appearance despite service, filing repetitive and frivolous objections, as well as misrepresenting the orders of the foreign courts. The court further remarked that such conduct amounts to an abuse of judicial process and underscores why execution mechanisms must remain efficient and effective. From a policy standpoint, the court reiterated that Section 44A was enacted to promote and ensure the comity of courts, reciprocal enforcement, and commercial certainty. Restricting simultaneous execution, the court observed, would not only defeat the legislative purpose but also allow judgment debtors to dissipate their assets while the proceedings linger abroad. In conclusion, the Honorable Delhi High Court held that the UAE decree dated 10th October 2023 is final, valid, and enforceable in India. It further held that the execution petition is maintainable under Section 44A of the CPC. Thereafter, it held, most critically, that simultaneous execution in both the UAE and in India is legally permissible. All objections raised by the judgment debtors were rejected, and it was decided that the execution would be proceeded with against their assets which were within the jurisdiction of the court. However, as stated at the outset, it's important to state herein, the decision has been challenged before the Learned Division Bench of the High Court, which is currently pending adjudication. This judgment provides much needed clarity on the scope of Section 44A of the CPC. It reiterates three vital principles. First, a decree from a reciprocating territory, once conclusive and when it remains unsatisfied, can be enforced directly in India. Second, there is no bar on simultaneous execution across jurisdictions. Third, procedural safeguards like the non-satisfaction certificate are intended to ensure fairness, not to restrict parallel enforcement. In essence, Honorable Delhi High Court has strengthened India's stance on cross-border judgment enforcement. reaffirming its commitment to international comity and commercial integrity. That's all for this episode of Legal Bites by INDIALAW LLP. If you found this breakdown insightful, don't forget to follow and share this podcast with your colleagues and peers. Stay tuned for more expert updates from INDIALAW LLP. Thank you for listening and see you in the next episode.